sovereign citizen in court. Hey everyone, welcome back. Today's case is absolute chaos, a full-blown conspiracy. Karen thinks she can strong-arm the court just by threatening lawsuits. She's convinced that prosecuting her without her consent is illegal and that the judge will cave if she repeats it enough times. Spoiler alert, that's not how law works. From the very first second, this hearing goes off the rails and you won't believe how it all unfolds. Let's dive in.
2300820M. This is Van Buren Township versus Lindsay Dineski.
Yes, ma'am, that's me.
On behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
Yeah, claiming a junior college application counts as studying to be a lawyer is a stretch, to say the least. She's textbook pro se constitutional expert. Someone who binges a few YouTube videos and suddenly thinks they've unlocked the secrets of the entire legal system. These folks are supremely confident, hilariously underqualified, and fully convinced they can rewrite centuries of law with just one overworked, lonely brain cell. Watching them try is equal parts cringe and must-see chaos.
That being the case, have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I think all charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights under the Constitution of both.
You said you were studying to be a lawyer, right? Well, if that's true, this should be Day 1 Law School 101. One of the very first lessons is the difference between an arraignment and a trial. Simple stuff. An arraignment is where you enter your plea. A trial is where evidence is actually presented. Confusing the two doesn't make you look like a legal prodigy. It screams, I have no clue what's going on. Watching her fumble through this is equal parts embarrassing and fascinating, so let's take a breath and see if she can actually get the answer right this time.
Thank you. The recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which is what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well.
And let's be real, this isn't the first time the court or its officers have faced threats from someone throwing around lawsuits like confetti. At this point, it's basically just background noise in the courtroom. Honestly, I'm more shocked that no one's tried suing Crayola for not putting a may cause brain damage warning on their adult coloring books, because the reasoning here is on that exact level. The logic is less about actual law and more about someone blindly following bad advice they found on the internet, convinced that yelling, "I'll sue you," somehow makes them untouchable. Watching this unfold is equal parts absurd and captivating. You just can't look away.
These are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court.
Honestly, I didn't think she'd ever stop talking, and forgive me for being blunt, but I'm not buying this story for a second. Police don't just show up and arrest someone out of thin air because they politely asked for help. That's not how reality works. There's always a bigger picture, and the louder she yells, the clearer it becomes that critical details are being conveniently ignored. This isn't some innocent request for assistance. It reads like a carefully spun narrative after things didn't go exactly as she wanted. And watching her insist on it with zero accountability? That's exactly the kind of over-the-top drama that makes courtroom videos this addictive.
In federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste of the court's time. The one who broke the law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the first.
Yes, but I could ask for it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
Adopting a child is a completely separate legal process. And without that, you have zero automatic rights to the biological child of another woman. The court can grant visitation, but only if it's genuinely in the child's best interest, based on facts, not a string of paranoid conspiracies. And this is where it gets wild. She's spiraling hard, convinced that the entire world is plotting against her, just because she's not getting her way. Watching someone spin reality into this level of chaos is equal parts baffling and entertaining. Honestly, I'd be shocked if the state ever thought it was a good idea to put a rock under her supervision, let alone a living, breathing child.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
At this point, a very obvious pattern is emerging. She refuses to take any responsibility and constantly pins the blame on everyone else. In her version of reality, the biological parents are villains, and she's the heroic savior swooping in to fix everything. But the truth is far messier and far less flattering. The child's father has been mentally abusive, and yet she willingly brought 2 more children into the same toxic environment. The kicker? The child she claims to be protecting has likely had the most peaceful, stable 2 months in recent memory, away from her constant interference. It's a classic case of self-delusion, where her inflated sense of righteousness completely overshadows the real impact on the kids involved.
Court, when gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me. She's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her. And I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age, because she was so behind due to the abuse and neglect from Charles and the bio mother.
Yes, discovery. That fundamental cornerstone of real legal procedure, not whatever imaginary law school she thinks she's attending. In the real world, this is the step where you receive all the evidence the other side plans to use against you, giving you a fair shot at preparing your defense. But in her version of reality, calling it discovery apparently makes it optional. And she still walks in convinced she's a legal prodigy about to topple the system. The audacity is almost impressive. How she can confidently twist a basic, well-established process into a sprawling conspiracy theory. Watching her strut around like she's reinventing the law is equal parts cringeworthy and fascinating, and it perfectly sums up why self-representation in court usually ends in chaos.
And now he tried to kill me. He said he was suicidal and then kidnapped our child. And then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So well,
that's what I'm asking for the agreement, due to the fact I was not given any evidence. I wasn't.
Exactly. Here's the reality check she so desperately needed. You can scream about conspiracies, claim every right under the sun, or insist you don't consent. But the courtroom doesn't run on your approval. Ignore a court order and the consequences hit fast. Your bond is gone, and your new classroom becomes the county jail. There's no negotiating around it, no clever loophole. This is Law 101 served cold and hard. Watching her confidently strut in thinking she can bend the rules, only to be slapped with this harsh reality, is a perfect reminder that self-proclaimed legal brilliance doesn't hold up when the gavel drops. Welcome to Karen's crash course in consequences.
Like, I have proof that Chuck took this and tried to use it in a court to try to kidnap the biological children from me. And the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they used to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am, the
And I would
court
like
will
to
mail
know why
notice-
I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal order.
April 20th with Judge Green, ma'am. The court will mail notice to the address that we have on file in this matter. Anything else, Ms. Manarino?
And no, Your Honor, thank you.
I do
Anything
not
else, Ms.
consent
Kowalski?
to this, by the way. I do not consent to this interaction. I do not consent to these charges. I do not consent to any of it. It is erroneous, and I will be taking legal action against this court for not dropping this today.
And that's a wrap on this absolutely wild courtroom saga, folks. Watching someone cling so desperately to their imagined rights while the real legal system methodically shuts it down is honestly mesmerizing. She's got another hearing coming up soon, and you can bet I'll be there covering every jaw-dropping, chaotic moment for you. Big thanks to Factor for sponsoring today's video. Hit the link in the description to check them out for yourself. If you love this courtroom madness, smash that like button. If not, go ahead and hit dislike. But don't forget to drop a comment with your take. And make sure you subscribe with notifications on. Trust me, you won't want to miss the next round of absolute chaos in the courtroom.